Welcome to the McNeese Labor and Employment Podcast Series. This podcast will address social media policies by Adam Santucci, attorney at law. Mr. Santucci practices in the Labor and Employment Group at McNeese.
Hello. Thank you for joining me for this podcast, which is going to cover some best practices for employer social media policies. Most employers have realized the value of developing and maintaining a policy. Social media policies protect the organization by educating employees regarding the risks of social media activity and providing guidance on what conduct is appropriate and acceptable. A quality policy will also help your organization protect its reputation, confidential business information, and resources. Social media has taken the world by storm, and many employees and employers may be rushing in without giving much thought to the consequences. Employees' social media use could have serious ramifications in both their personal and professional lives. And therefore, one key aspect of a good social media policy is employee education. Employees should be advised regarding the good, the bad, and the ugly of social media. Employees also need to be advised of the company's rules regarding social media use. Employees should be restricted from posting the company's confidential and proprietary information on social media sites and should probably be restricted from visiting certain sites during working hours unless that activity is job-related. In addition, do employees know whether or not they are permitted to speak on behalf of the company when posting on Facebook or Twitter? Some employers may want their employees talking about the products and services they offer, while other employers may want to control that message. Are employees aware of the rules associated with posts about the company's goods and services? If an employee is authorized to post on behalf of the company, who owns the social media account or its followers if the employees leave? All of these questions should be answered by your social media policy in order to protect the organization's reputation and to stay out of legal trouble. But before you go trying to set limits on what employees can or cannot post, make sure you have a firm understanding of the protections under the National Labor Relations Act, which applies to nearly all private sector employers in the United States. For example, the Act protects employees' rights to discuss the terms and conditions of their employment. This includes the right to discuss things such as wages, safety, discipline, the employer's policies, supervisors, and much more. The National Labor Relations Board, which is the body charged with enforcing the Act, has made very clear that employees may take to social media to discuss all of these things and to generally complain about their employers. In a series of decisions, the board has overturned employee discipline issued as a result of social media activity, including discipline issued for violating the employer's anti-harassment policy, discipline issued for mocking the employer's sales efforts, and discipline issued for vulgar insults regarding a supervisor. The board has made no bones about its goal of protecting employee social media use. Also keep in mind that employer policies that restrict or prohibit protected activities are unlawful. In fact, policies drafted in response to union organizing activity, policies implemented in a way that prohibits protected activity, and policies that can even reasonably be construed to prohibit protected activity are all unlawful. As a result, your social media policy will need to be crafted in a manner that complies with the Act and does not restrict employees from engaging in these protected activities. Despite the challenges that you may face as a result of the board's efforts to protect employee social media use, there is no doubt that all employers should develop a policy. A well-crafted policy will both provide guidance to employees and protect the organization. Given the complexities of these issues, we recommend that you work with experienced labor and employment counsel before finalizing your policy. If you have any questions about your social media policy or the protections afforded to employee social media use under the National Labor Relations Act, please contact us using the information on the screen.